Hi friends from around the world, let's go patent today. You know that this is not really a patent channel. I'm not a patent lawyer. I'm many things. I'm mediator, I'm diplomat, I'm old hands in intellectual property, but I am from the law side. I'm not from the chemical, from the mechanical, from the chemical, from the physics, informatics. Well, this is not my place really. But still, patent are intellectual property, and there are horizontal issues which have to do with patents and would have to do at the same time with trademarks. Why not? License, for example, is one of these issues which you have in patents and you have in trademarks or in any other IP, copyright, or you have it in designs. So it is something which is intertwisted, and from the legal side, my approach from the legal side, well, I feel confident in order to give you the facts of the case and some conclusions out of it. So this is about a license on one hand and arbitration on the other, alternative dispute resolution. So I will go over these two things, right? So let me see what are the facts of the case, and it goes a long way. It starts in 1992, where Hoechst, H-O-E-C-H-S-T, so that is a very German word, and is a chemical company in Germany, one of the big ones. Well, a predecessor of that company made a license agreement, a worldwide non-exclusive license agreement with Genentech, a German company, about something which is cytomegalovirus enhancer. Don't ask me what that is exactly. That has to do with something of creation of medicine, of pharmaceutical product or so. Well, there was a patent in favor of the predecessor of Hoechst in Europe on the EPO, European Patent Office, and 2 US patents, right? So they agreed in the license agreement, the worldwide non-exclusive license agreement between Hoechst on one hand as the licensor and Genentech on the other as the licensee. They agreed three things. First is a one-off fee of, I don't know, was it 10,000 or 20,000 Deutschmarks or so? And a second was an annual research fee. And the third was a royalty of 0.5% of the sales of the final product using that patent, right? So this is the situation, and then the one-off fee was paid, and the annual research fee is paid, but nothing has been paid on the royalties. And in 2008, Hoechst now was the owner of, was the licensor, so to say, as the successor in title, and it asked Genentech for, what happens with the royalties, which have not been paid. And they agreed to go into a arbitration proceedings in Paris, and that was in 2012 only. Now, in the meantime, the EPO patent has been revoked. You know what revocation implies? Revocation is ex tunc, meaning that from the beginning, so as it has never existed. Well, they entered into the agreement and into the arbitration agreement, and in 2012 there was the arbitration that was carried out in Paris, and it came to the conclusion, the arbitration proceedings, they concluded in 2014, and it said, well, the royalties were to be paid to the Hoechst, to the licensor, independently, notwithstanding that the patent has been revoked. And this was the trigger for Genentech to not be satisfied and to seize the Paris court for reasons of competition. And now here we come with the competition issue. There is Article 101 Treaty of Rome, you know, that the competition issues and the cross-border competition issues have been transferred, the competency has been transferred to the European Union. And there is, well, the Commission, and there are some regulations. And the treaty is 101, which says literally you don't have to put distortions into the market and not put competitive disadvantage into one and the other. Here it is on the screen. Now, the Genentech said in front of the court, well, this is against 101, so the agreement, the license agreement was against 101 from the European Treaty, that article. It was placed, so Genentech was placed in a competitive disadvantage with regard to other competitors who did not have to pay the patent fee, the royalties. And well, I have not paid, I was not due to pay these royalties because the patent has been revoked from the beginning. So why should I pay for royalties for a patent which is non-existent, so to say? So that was his defense, and well, it was not successful in the first instance. It went to a higher instance, and then the question was put to the European Court of Justice, referral court, you know, the proceedings. And it was about European law, that 101, interpretation of 101 of the European Treaty. Now, what does the European Court of Justice say? Well, what it does not say anything about the arbitration. You know that there was an arbitration proceedings beforehand, before the judicial proceedings, and arbitration is a kind of alternative dispute resolution, which normally has the aim to to be more flexible, more cost effective, to assure a neutral body in order to rule about the legal issues, to shorten the lengthy time frame of these judicial proceedings, etc., etc. Now, in that case, it is not coming to that aim, to that end, when you have arbitration proceedings at the end, which takes its time as well, and then on top of it you have litigation proceedings, so you have a double in time and probably also in cost in order to get to a solution of the problems. Why has it done here in that way and not in the other? I don't know. It is not being said here. My point here is different. My point here is that you, as a lawyer in alternative dispute resolution proceedings, such as mediation, such as arbitration, these kind of proceedings, they require your intervention. And your intervention is not only in these proceedings, but it is also beforehand when a license agreement has been drafted, or when with subsequent arbitration proceedings that can be possible, or if you have been entered once the dispute arises. So once Höchst, in that case, Höchst wanted to have the royalties being paid by Genentech, and the people, so these two parties enter into arbitration agreement, then this arbitration agreement should have been done in a good way, beneficial to the parties. And the benefit of alternative dispute resolution is precisely not to go afterwards to court, but to have everything ruled out in that proceeding, if you want to go into that, right? So this is my point. You have to draft correctly, because afterwards, normally, once you have the arbitration agreement being done and arbitration resolution, the legal supervision of that resolution is very limited, and should be so, and that is, the final aim. So here it went to the European Court of Justice, and about that part, the ADR, the Alternative Dispute Resolution, there was not really something which was discussed by the European Court of Justice. That is not part of the question. So the European Court of Justice, they have to limit itself to the question. And here there was an admissibility issue about the question, but I do not want to go into that. But I want to go into the second issue. The second issue is about the royalties, and royalties for a revoked patent. So the parties in the beginning, they made a patent agreement, then the patent was revoked, and still the licensor insisted in being paid the royalties, although the patent has been revoked. And the argument from Genentech was about competition law, right? 101 of the European Treaty. There was a previous court ruling, Ottung, in 1989. And this was the one the European Court of Justice first referred to. In this case, Ottung, there was a expiry of the patent. Was it a patent or was it a trademark? Can't remember. Well, it is here on the screen, the court ruling. There was an expiry, and the agreement on the license agreement has been before the patent even existed. So it was in the granting proceedings. And after expiry, and they said in general, well, the competition rules have a function in order to assure that the market is free of competition and that no dominant players, and they are not, they're not tied to something. And in that case, they said, well, it is competition is not about the interfering in private agreements. So there may be a commercial logic behind what has been contractually agreed to, which escapes whatever hindsight you may apply to anything. So if you are in agreement, you know that, and you want this for whatever reason, you agree to it. And in hindsight, it may play out or it may not play out, but it is not in competition law to bail out somebody who was erred in the beginning or who had a different imagination of how things will play out in the future, and to bail out that person. So that was the logic behind, and the logic here was applied in the same sense, meaning that even if it has been revoked, the advantages of the licensee was still there, because he was not subject during the validity of that license. He was not subject to any license infringement or proceedings against this, and he was, so to say, protected, and he felt protected. So that was still an advantage which has been so to say exploited by the licensee at the time. And on top of it, and that was an important issue for the European Court of Justice, that the licensee was able to get out of the licensee agreement with short notice. That is an important issue because if you are tied up into the license agreement for another 10 years and the license is being revoked, so there might be a kind of abusive power with regard to that, and well, that would be something where the European Court of Justice would have probably ruled differently. So what is the outcome of that case? Well, you can be confined, so to say, to hold to the contract even if patent or a trademark has been revoked. So the contractual agreements are more important than any other official or public interest rules existing, such as the competition law. There's, however, an intertwist between one and the other, right? So, but if you're not tied up into an agreement for a long time, although the situations have changed, then there is a possibility well, there is the contractual agreement, which is the one which is dominating the relations between the parties. And this is now a clear rule, meaning that the license agreement are more important. Well, they are more important because you cannot be bailed out by the public interest rules, provisions. So this is the blood life of the lawyer, to put in place the right contract and to shield the clients from future problems they may encounter otherwise. And here is a problem which may come into play when you have a license agreement. What about the underlying IP right when it does not exist anymore, when it is the invalidity proceedings against the trademark and which succeeds, so there is no trademark anymore? What is the advantage you have, and why would you want to pay afterwards the license fee or the royalties? Now, there is one last thing I want to have in mind. I had in mind when I read the case, which is a Roman principle which says clausula rebus sic stantibus, which means that if you have something which is tacitly implied in an agreement and which is an important part of that agreement, and at a certain moment that part does not exist anymore, then the contract falls apart. That is what I would have applied here in this case, but it was not raised by anybody, any party here. I didn't read anything about this. But does this exist? I'm interested in. Does this clausula rebus sic stantibus, does that exist in your home jurisdiction? I don't know.